always jump that. Should I say it again?
No, you're good.
Okay. May I have a roll call, please?
Darrell, aye.
Jeff, aye.
Lynn, aye.
Michael, aye.
Bryce?
Eric?
Eric, aye.
Erica?
Aye. Oh, thank you. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. First thing tonight is approval of the regular agenda. Does anybody have any additions, corrections, subtractions? Nothing. May I have a
I will make a motion to accept the agenda as presented.
I'll second that.
motion by Jeff, second by Darrell. All in favor?
Aye.
Aye.
May I have the approval of minutes for February 12th? Are there any adjustments anybody would like to make?
No.
No.
May I have a motion, please?
I'll make a motion to approve the minutes of February 12th as presented.
And
I'll second that too.
Go.
motion by Jeff, second by Darrell. All in favor?
Aye.
Aye.
Are there any declarations of conflicts of interest this evening?
No.
None of that. Are there any public comments? There are nobody in the audience. But is anybody on Zoom?
I have no raised hand.
Okay, so that was ended. Special presentations, we have none. Design review and land use public hearings, ordinance TBD, series
Except
2025, an ordinance amending chapter 13, 16, and 17 of the MMC Minturn Municipal Code to incorporate into its code existing restrictions the connections to the town water system based on limitations of available legal and physical water supply. Are you taking that, my dear?
I am. So on that mouthful of an ordinance title, based on, it is my understanding that based on recent legislation, we can no longer have a long-term moratorium until the water treatment plant is, finalized and we have greater water capacity, and instead we are essentially codifying the moratorium into the code in chapters 13, 16, and 17. Chapter 13 because it is the utility portion of the code, chapter 16 and 17 because that deals with development, and that's when water becomes needed. So within the ordinance, you'll see amendments to all three of those chapters, essentially chapter 16 and 17 of which y'all have purview over, stating that any application for new development that will need to get a letter from the town clerk, essentially stating that there is enough water to supply their project with what they need. So that is a very brief explanation of an ordinance that I did not write. The attorneys wrote this and they told me that it needed to get passed. So I'm here to ask you to pass it to council.
We have public comment open last time.
Public comment was open last time, yes.
There's no one, we'll open public comment. There was no one here. Is there anybody on Zoom?
I have no raised hands on Zoom.
So we can close public comment and then come to commission.
I had one question. In the past, we have not required to have that letter from the town manager saying that there is adequate water.
No, that's certainly something that we flag for people who, especially if they're coming in wanting to, subdivide one property into three, we flag that at the staff level saying, hey, we just don't have water to do that, based on our water moratorium. But that's really something that's become pertinent at building permit process, because building permits when you make an application for a new water tap. So this is essentially kind of making it, we don't do letters now, but we certainly talk about it with applicants. This is just kind of making it more official, and then so that we can essentially remove the moratorium.
But in the future, we'll probably see a letter or a copy of a letter.
It'll either be noted in the staff report likely that, the applicant received a letter, or a copy of the letter will be included in your packets, yes.
Okay.
Jeff, do you have anything?
I do. I don't know that anybody's gonna be able to answer or help me, but, under section 13.2.10, I would just request maybe some answer to this under section D. The town reserves the right to revoke any prior approval before service has been provided and the right to revoke service after it has been commenced for any violation of this chapter. So I don't know exactly. The town reserves the right to revoke any prior approval in the event that you violate some other part of the chapter. So I guess, you know, you have to do something wrong, I'm guessing, to get slapped on the wrist for that. Do you guys agree that that's what that's?
I
I would
understand what
think
you're
it,
saying.
yeah, that makes, like, if things go completely south, like things have gone in the past, well, then
It's-
they were gonna slap it.
I mean, I'm guessing it's just kind of a catch-all.
It is, and if you'll notice that section isn't double underlined, so that is an existing section within the town code right now.
It already is there.
It is already there, and I've never seen that section put into place, but I would think that that would come from if somebody illegally tapped into somebody else's line, they tampered with their meter, something, you know, they did something against chapter 13 utility code in violation.
Gotcha. And then the other question I had was, and again, I think this is probably questions that are better brought up at the council meeting, or maybe when there's water attorneys in the room. But there was a part of the, it wasn't like the allocation. It basically said that your historic use, in the event that you scrape your lot, you don't get credit for it anymore. I'm kind of paraphrasing, but it was basically saying, like, if you buy a lot, if someone buys a lot with a house on it that has a historical tap, they scrape it, they not only have to pay for a new tap, but they have to pay the system improvement fees as well. So it's kind of almost like you don't, and I feel like that's new. I feel like you used to be able to have the historical use.
Well, and then the question would be,
If you were paying the bill,
you know, if you scrape it,
I'm trying to
do you
find.
still get that one extra?
I think the way I read it, you still get the one extra, but I think it has more to do with the fees that you
And
pay.
what chapter is it in, do you remember?
I want to say it was around like where the system improvement fee table was. On page, well, I guess it would be page like 19 of the packet. Hold on. Forgive me. Because they gave examples.
here we go, it's on 18. I see the example, I haven't read it yet, but it's 13.220, it looks like.
Yeah.
An example where an existing structure is scraped and redeveloped.
No credit shall be given for the prior structure size, and the system improvement fee shall be calculated as though it were a new structure. So it's not that that you have to pay for a new tap. It's that you have to pay for the.
Increase in your square footage.
What subsection is that?
It is 13.220
Okay.
B.
That makes sense though, Jeff. I mean,
Under
technically, if you have a lot and you currently have one SFE.
Yep.
And you sell your lot and your SFE transfers with the sale of your property.
Yep.
And you scrape the lot and say you build a 6,500 square foot house, well, you're gonna pay the difference between your one SFE and whatever else is required.
But you're gonna pay the system improvement fee based on the size of your new structure, not the size of your new structure minus the size of your old structure.
I don't,
Which, again, this is not double underlined, so this must
Right.
already be there.
This already exists.
So I'm just kind of beating a dead horse.
It's good things to bring up. There's not much.
I know I can't fight any of this.
It is my understanding that a lot of the Chapter 13 code is kind of not necessarily set in stone, but a lot of it's kind of frozen right now while we go through all of our water court cases. So that might be something to bring up in the future once our water court
I
cases have been
think this is
resolved.
the first time I've ever seen chapter 13.
Me too.
It's not a chapter
I've seen
that
17,
y'all
but I haven't seen
typically
13.
go over, but since it's all in one ordinance, y'all are seeing it today.
But is chapter not to get down the rabbit hole, but is chapter 13 like new since the moratorium, or has there always been a chapter?
There's always been, at least as long as I've been here, there's always been a Chapter 13.
It obviously doesn't apply to P and Z.
Y'all are not typically involved
But you can
in
still ask questions.
water applications.
Well, in the interest of time, I'll shut up.
Prior to-
here, I'll talk for a minute since you started. On page 6 of that same section, for example, accessory unit fees, number 2, tap fee, the addition of any additional unit does not require the purchase of a separate tap, but would otherwise result in additional SFE, shall be charged
Half.
SFE,
Mm-hmm.
and as well as it's probably just written that way, but I think it, like if you add a accessory dwelling or whatever, it's 0.5 for up to 750 square feet, and over 750 square feet, it's a full SFE, is that correct?
That's where the water code differs from the zoning code. So zoning code limits accessory dwelling units to 1,200 square feet, whereas the water
Whatever.
code limits it to 750. There's discrepancies
But
that Jay
anything
and I have
over
butted heads
750
over.
is a full SFE, not a half.
Kind of. It's really what is termed an accessory dwelling unit, and there's discrepancies between the two chapters. Jay and I have definitely butted heads over that before.
Yeah. But no matter what, if you have an accessory dwelling, you're paying 0.5.
Yes.
Tell me how it reads one more time. Currently zoning is 1,200. And what's 750?
750 is the utility code.
Utility code.
I'm just making it.
I like that you just have
So
that.
take a look at that. So
The only reason I know is because I paid. Sorry.
Okay.
All right.
okay, I have nothing. Thank you, gentlemen, for those questions.
Worthless.
So therefore,
So we're going to make a motion. I'd like to make a motion to approve Town of Minturn, Colorado ordinance number TBD Series 2025, an ordinance of the Town of Minturn, Colorado, amending chapters 13, 16, and 17 of the Minturn Municipal Code to incorporate into the code existing restrictions on connections to the town's water system based on limitations of available legal and physical water supply.
Second.
motion by Jeff, second by Michael. May I have a roll call vote, please?
Michael, aye.
Lynn, aye.
Jeff, aye.
You're right.
Thank you.
Eric,
Eric, I. Eric, I.
Eric, jump in there, please.
Eric, I.
He did.
I have a tendency to forget the ceiling. Thank you. Okay. Discussion direction items, Minturn 4, land use code update. Is Matt here tonight?
Matt is online.
Hello, Matt.
Hi, Matt.
How are you?
Good.
Good, how are you?
Doing pretty well. Are we ready to jump in?
You're ready to jump in.
All right. So there's two, there's a revised article, Article 8 in front of you this evening, and then what's hopefully the final draft of the minor PUD amendment section. And I'll just walk through the memo that was included in your packet, and if there's any questions, feel free to interrupt me and we can discuss those. In terms of the revised minor PUD amendment section that's in front of you, we revised that based on the direction from the last planning commission meeting. And so the changes that were made The first is we've added language that clarifies that any relocation of a building or structure in a PUD must comply with the applicable dimensional requirements, so setbacks, building height, etc. We've added 2 new submittal requirements to ensure that if an applicant is proposing to increase residential units and/or non-residential square footage, that there's adequate access, parking, utilities, other infrastructure, water, etc. So they, as part of their application for a minor PUD amendment, they have to provide evidence that they have everything they need to serve the additional units and/or square footage of commercial industrial buildings. We've added a review criterion that states that no minor PUD amendment can result in a reduction in parks and/or open space within the PUD. We've added public notice requirements, and we mentioned this at the last meeting, but I just wanted to reiterate that. So so a minor PUD amendment is handled through an administrative decision, but the date of that decision has to be noticed, posted on the property, and then it has to be mailed to adjacent property owners or property owners within 200 feet, published in the newspaper, and then also a sign posted on the property so that folks have an opportunity to submit comments to the planning director. And then there's also a new provision that that requires an administrative decision on a minor PUD amendment to be placed on the consent agenda for town council, and then town council has the opportunity to call up that decision. Any questions or comments on the revised minor PUD amendment section?
Matt, I just have one comment, and
Yep.
I think it runs throughout the whole packet you gave us. But where it says mail notice, I assume that's going to be in where it is accordance with the date and timing on that.
Yeah. So what I think where our plan is
I'm
we'll
sorry.
have a. Sorry.
No, go ahead.
Oh, so yeah, anywhere where it says in accordance with section for the notice requirements, there's going to be another section in the land use code that specifies, that has all the detail for mailed notice, published notice, and posted notice. A lot of that's already in the code today, but there's that we're just going to create another section, and anywhere in Article 8, which is subdivision applications, or Article 5, which is land use applications, anywhere where there's a reference to notice, it'll say refer to that section for all the details that you need to know about the different notice requirements.
Thank you.
Yep.
I just have one thing to say, Matt.
Well, he's only 3 years.
What's that?
Are we there yet? This is
In regards to what we were just talking
Okay.
about?
Yeah.
In regards to what we were just talking about, 2 things. One, thank you, staff, for the highlighted packets. Makes my brain work a lot easier. And
Me too.
and Matt, thank you for adding some of this stuff that we talked about, because I remember that we did talk about it, and I think the other stuff you added as well looks good. So moving on.
Anybody else?
No.
No. Go ahead, Matt.
All right. So the other chunk of material that's in front of you tonight is a revised draft of Article 8, which deals with subdivision application requirements and procedures. And we did our best to highlight the changes in there. There weren't a lot of significant changes, but I tried in the memo, tried to provide an overview of some of the key changes that were made. And again, I'll just walk through these quickly. So the first is the purpose language at the very beginning of Article 8. I think last time you guys saw it, it was a bit of a jumble, that was pulled directly from the existing code. So we've worked to clean that up. Hopefully it reads better, it makes more sense. The other issue with what's in the code today is it really focuses on subdivisions of land. It doesn't address subdivisions of buildings. So we've tried to ensure that the new purpose language clarifies that a subdivision can be either of land or a building. And in the case of a building, that would be taking a building and subdividing it into condominiums or a duplex or townhomes. Let's see, there were some missing public notice requirements from the table. The last time you guys saw this. So we've added public notice requirements for duplex, condominium, or townhome subdivisions, exemption plats, and minor subdivisions. The exemption plat section was, I think we were still working on that last time we provided you with this. So we've since detailed the whole exemption plat section. There is still some work that we're doing and working with the town attorneys on to clarify sort of when an exemption plat applies. And really the intent of an exemption plat, based on my discussions with staff and the town attorneys, is to allow, have an avenue for somebody to come in and clean up a property that maybe was created a long time ago, wasn't created through the appropriate processes. So it provides an opportunity to clean up title and maybe create a plat if there's not a plat, things like that. So we need to make sure that the applicability language for exemption plats works for what the intent of that section is. But throughout that section, we've added a purpose statement, submittal requirements, review criteria, and then also detailed the review process for an exemption plat. And next is the requirements for duplex and condominium or townhome subdivisions. I think we've already discussed this, but we did add language in there that says that an application for that type of subdivision cannot be submitted until the framing of all party walls is complete. And the reason for that is, I think as we've discussed previously, you need to have the framing in place in order for the surveyor to accurately do their job and create a plat for the condominium or duplex. So that's the reason for that requirement. The next is, and this is based on direction from the Planning Commission, we've added language that states that any building that's subdivided through this process has to also comply with all the applicable requirements of the town code, and sort of specifically building and electrical codes. So it's a little bit of it might be a little redundant, but I think it's good. And again, based on the Planning Commission's direction, I think it's good to have a statement in there that says, if you're going to take an existing building, you're going to have to make sure it meets code, other code requirements in addition to the subdivision requirements if you're going to subdivide it. Next is minor subdivisions.
Excuse me, Matt. Daryl says he has a question on that.
I have a question on that one. You were saying, with other entities such as electrical, plumbing, that would also include like firewalls and that kind of idea, is that correct?
Yeah, so building code, and I'm not necessarily an expert in building codes, but my understanding is building code, if you have shared walls, firewalls are required. I don't know if Minturn has adopted the International Fire Code, but yeah, I mean, to your question, this statement means that if you take an existing building and it's maybe not up to code or has problems, you're not exempt from bringing it up to code. You still have to do that.
Oh, I see it right below where you have adequate utilities such as electric, gas, internet, telephone, etc. The next line says adequate fire protection. That answers the question.
And on the next page, Daryl, it has at the bottom of page 58, under number 8, It says, if an existing building or buildings are to be subdivided, evidence must be provided to demonstrate that the subdivision of the buildings will comply with all applicable building code requirements.
Okay,
So I think that kind of also helps.
And Matt, we have adopted the 2021 International Fire Code.
Okay.
Eric, do you have anything? Eric?
No, not yet. No.
Okay, thank you.
Sure.
Go ahead, Matt.
All right. And I know I'm cruising through this fairly quickly. So definitely feel free to interrupt. So the next section that we've detailed is the minor subdivision section. And this again, I think was a section that was blank the last time you saw the initial draft of Article 8. So we've added applicability criteria. So that criteria determines when a minor subdivision process can be used. And it says things to the fact that a minor subdivision can only create up to 6 lots. You can't have any sort of public improvements outside of curb, gutter, and sidewalk. You can't have any dedication to right-of-way, things like that. And if your property you're wanting to subdivide was previously created through a minor subdivision, you can't use that process again. And the idea there, and I believe we've discussed this previously, but the idea is to prevent somebody from, or it kind of closes a loophole that somebody might try and utilize to avoid doing a major subdivision. They might try and do a minor subdivision over and over again to go from, say, a 20-acre parcel down to, say, 5 4-acre lots, and then take one of those lots and make those smaller. So it's really a one-time deal, and it's intended to accommodate sort of a very simple subdivision. So that's the criteria that's in there to clarify when that process applies. We've also detailed the submittal requirements for minor subdivisions, review criteria, and then the review process. I will note in the existing code, minor subdivisions are reviewed and decided on through an administrative review process. And that's the process that at least staff is proposing, that minor subdivisions continue to be reviewed through an administrative process.
But that still can be taken to council and called up by them, correct?
Not currently.
I don't believe so. I don't think we've added any provision in there that allows the minor subdivision to be called up by town council.
Do you have any concerns over that?
No, I have more of a problem trying to figure out where it applies in town.
The one place I can think of it applied in town was the end of Boulder Street, when Tom Sullivan had that minor subdivision there.
Mm-hmm. But that did go through an administrative process.
It went through us, yeah.
It did?
Yeah. I remember discussing it.
I remember discussing the land use of it. I don't remember necessarily going.
Maybe I remember the houses.
Yeah, I don't remember the subdivision process.
Right.
I feel like that just, once we saw it, it was already subdivided.
Yeah, it might be just when the houses came in that I'm thinking.
Because that's currently how the process works, so.
And that's the only one I remember.
I do think that one somehow made its way to council, because I remember Arnold telling me
There
that
was an issue there because of an easement behind those. and
Right.
To do with
So
water.
I think Janet processed it, it went to council. Arnold got up to talk about how it would be beneficial for the town to be the beneficiary of that easement for the snow storage. So somehow it made its way to council, but that was far before I got here, so I'm not sure how that happened.
But that's the only one that small that I can remember.
We had the Lucero subdivision that was subdivided into 3, and then eventually one of those was subdivided again
Well,
into
what about
2.
Sibley's?
Sibley's will be a major subdivision.
That would be amazing.
So we certainly have had minor subdivisions in While I've been here, amended final plats fall under a minor subdivision, so anything to combine quiet title parcels, that's been technically a minor subdivision. So those are all things that have been staff processed.
What's it say, staff is up to 6, is that?
Up to 6.
I don't have a problem.
I don't have a problem with that. And I think really if there was a problem, I think council could step in if they wanted.
I mean, the mayor still has to sign the plat.
Yeah.
So
So,
And typically, it's gonna be a neighbor that has a problem with it, that's gonna red flag it anyway, because it's gonna get
Oh, that's
noticed,
true.
right? It's gonna get noticed. If a neighbor has a problem, they're gonna go to the town and they're gonna say, hey, I got a problem with this.
things change. Okay, anybody else? Thoughts? Go ahead, Matt.
All right. Next, and sort of the final piece to the Article 8 is major subdivisions. And what we've done in the existing code, it's a two-step process where you have a preliminary plat, which is where a lot of the heavy lifting, a lot of the design work is done, and then the final plat, which is where you're kind of cleaning things up, making sure everything is ready to go and to get your subdivision recorded. We've added an optional sketch plan step, which is it's similar to a conceptual development plan for a PUD. It's an opportunity for an applicant to come in and say, "Here's my idea for my subdivision," and it gives them an opportunity to talk with the planning commission as well as town council. There's no formal decisions that is made by the planning commission or council. It's kind of, yep, looks like a good idea, or here's some concerns I have, sort of thing. So it's a little bit sort of like a work session, but it's a bit more formal than that. So we've added so that sketch plan process is a new step, and again, it's optional if an applicant wants to do that. Because the next step is preliminary plat or plat, yes. And like I said, there's a lot of time and money that goes into your design of your subdivision at that step. So it gives an opportunity for somebody to come in and test the waters before they spend a bunch of money. And so we've added a purpose statement for the sketch plan step, submittal requirements, review criteria. Actually, I'm sorry, that should say evaluation criteria, because again, it's not really a technical review of the application. It's here's some things to consider for the planning commission and town council to consider while they're looking at this concept for a subdivision. And then the sort of evaluation process for a sketch plan. For both preliminary plats and final plats, we've worked with the town engineer to list the various types of construction plans and studies and reports that would be required as part of both of those steps in the major subdivision process. What we're still working with the town engineer on is trying to detail as best we can when we say geotechnical report or a traffic study, kind of what exactly we need to see in those studies. And what we're proposing is that anywhere in the code where it says you have to submit a geotechnical report, it's just listed as a submittal requirement. And then it will refer or cross-reference to this new section that we're proposing that will have all the detailed requirements for the different types of studies and plans that could be required as part of an application. So in the draft of Article 8 that you have, it says plans prepared in accordance with section, and it's a placeholder right now, but that's that new section that we're proposing be created that will kind of house all the detailed requirements for the various types of plans, studies, and reports that could be required.
Matt, Michael has something?
Yep.
I just have a question, I'm sure it's already answered here in this packet, but on the minor and all the subdivisions, the new ordinance we just passed in regards to the water system based on limitations, obviously staff or somebody is making sure that,
That will need to be incorporated.
what's What's that?
I said that will be, need to be incorporated into whatever we eventually adopt as chapter 16 and 17.
Yeah, to make sure that everybody's got their water, right?
Yes.
Yeah, and I believe for both minor and major subdivisions, there's a submittal requirement and then a review criterion that says you've provided evidence that you have an adequate legal and physical supply of water for each lot you're going to create. So it's sort of baked into the subdivision requirements that if you're going to subdivide your property, you have to have water and then of course all the other utilities and then access, things like that.
Great answer. Thanks, Matt.
You bet.
Matt, I have a question. Can you go backwards a little bit and tell me when I can look for it and read it? The, what you were talking about, there'd be like a
For water?
a casual work session.
Oh, yeah, let me find sketch plan. Sorry. And I'm looking at my memo so that the paging might be off. It's, sorry, I'm still looking for it here.
Page
It
90.
starts, yeah, on page 64 of Article 8.
Okay, thank you. I can go back and look at that again. I read the whole thing, but sometimes you get a little lost.
Sure.
Okay, go ahead.
All right. Sorry, just a second here. So we've also modified the review criteria for the preliminary plat process, or step of a major subdivision, to try and ensure that all the key components of a proposed subdivision are considered in the review process. There's two criteria that are highlighted that deal with the siting of residential lots. One of the criteria, I'm not going to be able to regurgitate it exactly, but the gist of it is that our residential lots located in a where you kind of have convenient access to, if there's businesses, restaurants, things like that in the subdivision, are the places where people are going to live sort of logically located so that folks can walk to businesses, restaurants, things like that. And then the other criteria is trying to ensure that new subdivisions provide different opportunities or a range of opportunities for different types of housing for folks trying to again further diversify Minturns housing supply. Those two are new criteria. I don't know if the planning commission has any questions, concerns, comments about including those.
No, I think they're good.
I have one because I think it's page 111. Lots for residential uses are located in a manner that provide residential convenience. And uses provide a diversity of housing opportunities for people varying income levels. I assume that's what you're referencing.
Correct.
Does that reference your note on page 27? Staff is proposing to include new criteria. Is that what you're talking about there?
It is, yep.
Okay, thank you. I just want to clarify that.
Yep.
What page are we on? Just so,
111 is
no,
where,
but currently what he's.
well, that was what he just spoke about.
He was on page 111.
Yeah, so there's two new criteria for a preliminary plat.
111 of the packet.
111 in the packet.
Yeah.
Oh, okay, then, I might have missed something.
Michael has a question.
Sure.
I might have missed something because it wasn't highlighted, but it's sort of in orange. So I don't know if we jumped ahead to 111 or
We did.
we did.
Yeah, go back. Go ahead.
On page 89, Matt.
Yep.
89, where we talk about,
Vacation of public right away.
yeah, where we're talking about vacation of public right of way, and it says, no vacation of what it says here, that you type, no vacation of public right of way or easement shall become effective unless quitclaim deeds have been duly recorded with Eagle County Clerk and Recorder that cumulatively relinquish all rights, claims, interests, and all interested parties, including public, private, utility companies, and have subject to right-of-way easements. That one specific section, actually, it's not highlighted, but it caught my eye. In regards to that, Matt, I looked up the old existing section that we have, 17.9.20, and the reason I bring this up is because one, maybe I need to have a little conversation, a little clarity on this. Public right-of-ways, you know, currently we've been talking about amongst ourselves in regards to potentially quiet titling river bed or whatever, and you know, and there's been lots of talk about access, and that being said, public right-of-way, in regards to referring to it as public right-of-way or easement, public right-of-way, does that constitute like streets as well? Sort of a question. And you know, mainly looking at the old section that we had in there, one, if we're gonna vacate a public right-of-way, I don't think that we should be making it easier. You know, the old section has 4 pages, and this is down to 1 paragraph. And technically, if you're going to vacate a public right-of-way, if it's a public right-of-way, if it's an actual road of the town, well, like for example, when I built the car wash and owned that building, there was a section of land in between it, and we held a public election, and I paid $50,000 for that public right of way, and the old code section of this code talks about a lot of stuff, notifying everybody and their brother and this and that, as well as if you're vacating a public right of way, quitclaim. I actually know a lot about quitclaim deeds, stuff like that. Quitclaim deeds, for example, if it's a public right-of-way, you would need a quitclaim deed from the town itself, because the town itself represents the public. And so, you know, that being said, being that, you know, we have concern, you know, we talk about access and access to everywhere else. And as far as quitclaim deeds go, if you have anybody can get a quitclaim deed. If you have a quitclaim deed, then you can take your quitclaim deed and you can go through a quiet title process. If you go through a quiet title process, it goes to the town, gets advertised in the paper, notifies the neighbors, and goes to the court, and it gets given to you. Then you potentially have 2 lots. At a certain point, you have to go in, you have to eliminate your lot lines, because you can't build over your lot lines because you have 2 lots. It's actually still a separate lot. That being said, that's one way that you can own property from a quitclaim deed. The other way you can own property from a quitclaim deed is if you get the quitclaim deed, you go record that at the county, and you pay taxes on it for 8 years. And after 8 years goes by, you have a legal claim of ownership to that property. That all being said, and we don't have to go through it all now, but I think that we should definitely highlight that section and look at the old section. And I don't mind reading, but there's a lot. I'm not going to read these 4 pages of the old section.
Mm-hmm.
You know, I'll just hit 1 paragraph. No approved vacation of any road or easement shall be effective unless the following condition has been met within a reasonable time of approval by the town of any petition to vacate. Quitclaim deeds have been duly recorded in the office of the clerk, and interested and all interested parties, including public and private, may have in the road or easement to be vacated. But there's all kinds of stuff in the old section talking about notifying the neighbors, and basically it just comes back to the point of maybe vacating something else. Maybe I just think we need a lot more clarity on what we're vacating, whether it's a road or whatever that is, and if we're vacating it, and it's a public property or a public right-of-way that's been a public right-of-way, a quitclaim deed's not gonna do it unless you have a quitclaim deed from the town, so maybe staff and everybody can just make notes to highlight and think
Matt,
about.
can you put that on further discussion?
Yeah, and that's actually, I think that's why that under the applicability on
I saw
that
that.
that bullet point is highlighted, because I think that's something, and we're still waiting on feedback from the town attorney on the entirety of this revised draft of Article 8. So I do apologize if there's things in here that maybe aren't fully cleaned up yet. But yeah, we can revisit vacation of public right of way or easement, but to your comment, I mean, that would be a vacation of a right of way for a street, an alley. I mean, any sort of right of way that the town owns or an easement that the town owns. This would be the process that you would go through if you wanted to request that the town vacate that. I agree that making it difficult is a good thing. Anytime I hear of a town vacating right of way, I think it's not a good idea, because it's a tremendous asset that the town has, and getting rid of it, unless there's sort of a very strong reason for it, it shouldn't be done, in my opinion. And in here, there is a petition that says you have to, as part of your application, if you're coming to the town and saying, I want you to vacate the right of way next to my property, you have to get the signatures of all the other owners who have property that abut that right of way. So there is a lot of notice that goes into this, and then there's also a hearing with the town council. So it's definitely not intended to be something where you just come in, submit an application, and there's no public hearing or anything.
No, I saw your comment and your note on the side, and like I said, I just pulled it up, and the old section, we should give the old section, to Mike, and then you guys can review it and talk about it some more. And I think Daryl might even been on council when I paid for my own election to buy the road. And $50,000 was a lot of money in the 90s. And if we're giving out roads, we shouldn't be giving them away just because somebody wants it.
Matt,
Right.
Daryl has
Yep.
something, please. One moment. Go ahead.
Yes, Mike, I was mayor when you were doing that. And there was a question, how do we do the quitclaim as a town? Also, that the extension of the street went from Boulder to Pine, in between the church and the Bellums. That was never changed. That still is an easement.
Correct.
So we just did yours and we had to separate the whole thing out
Correct.
because it was one street. I forget the name of the thing.
There.
There.
Yeah.
So, it was pretty complicated. And just like it's saying here, one paragraph, that doesn't do it.
Well, I want to clarify that that's just the applicability. I mean, the whole process is 6 pages long. It is not just that one paragraph.
Right.
That's just the paragraph that we've highlighted as this was taken straight from our
Right.
existing code, and we'd like the town attorney to look at it.
Oh, okay.
Yes. We have not condensed this one process down, this entire very public process down to one.
Well,
paragraph.
no, that's just something that caught my eye. So I didn't realize we still had a whole nother section.
Yes, the whole section is 6 pages long.
Okay.
Anyway, whatever you come up with, if you could just let us know, that'd be great.
It was complicated.
It looks like it still is.
What year was that?
I will add, I think a lot of it is driven by state statute. I mean, I think when any sort of municipality gets rid of publicly owned land, it's not a simple process. So,
Eric, you have anything?
Good, 1 second.
Eric? No, I guess he's not here. Okay, Matt, go ahead.
all right, I think we're on the last bullet point here of the memo, and so just wanted to note that we did have a discussion with the town attorney a couple weeks ago and looked at the language for the duration of an approval for a preliminary plat and a final plat, as well as the language for extending if somebody has an approval and then they, for whatever reason, need to request an extension of that approval. Both a preliminary plat and a final plat are considered vested rights. And there's a whole section in the town's code right now that deals with vested rights. But essentially, we've changed the language for preliminary plat and final plat, the duration of an approval, and then the extension of approval to just defer to that section on vested rights, because vested rights is driven by state statute. So when you get an approval, I think vested rights, you have 3 years unless you get some other duration approved through your approval process. So we just, I think for the sake of keeping the code clean, we're just going to defer to the section on vested rights.
Anybody have anything on that?
I have a question,
On that?
I guess, maybe. So, Matt, that section is relevant, like, for example, when we pass something with a condition that, you know, a plat is done, or a lot line is eliminated as part of our condition, what we pass is different than what you're talking about specifically in the timeline of vested rights in this section, correct?
So if you had a preliminary plat that was approved, that would be considered vested rights. And the gist of vested rights is you have, once you get an approval as a developer, that vested rights period just means that the town can't change the rules on you and then force you to come into compliance with the new rules. You have a certain duration where what you got approved stays in place. But once your vesting expires, and vesting doesn't expire if you do your subdivision, things like that. But say you get an approval, you sit on it for over 3 years, then your vesting goes away, and the town could say, hey, look, you need to come back in and bring your subdivision up to these new standards that we've adopted. That's kind of the idea behind vested rights. So once, and I think the default, and I'm sorry, I'm not necessarily an expert in vested rights, but I think the default is 3 years. So once you get a preliminary plat or a final plat approved, that approval is good for 3 years. Once that goes away, it doesn't mean your subdivision goes away, but the town could then say, you need to come back in and bring your subdivision up to our current regulations. I don't know if that answered your question.
Yeah, I might have been talking about just something different. I understand what you're saying, invested rights, is there's a time frame that people have to do whatever they're supposed to do, and that time frame is specific, like, say, for example, 3 years, like you said, as it's
Right.
listed. And I was just asking an off the wall question that probably doesn't have anything to do with vested rights. I was just asking, like, for example, when we've vested rights doesn't mean if we tell somebody this is a condition upon your approval for something that we approve, they can't come back and say, well, our vested rights say we have 3 years to do it.
Oh, no, you're right. That's conditions of approval are different. So there is language in the code in this Article 8 that says your plat won't be recorded with the county unless you address all the conditions of approval. So there is language in there that says, because there's also probably, I mean, the plats I've dealt with my own private clients, there's always, little nuanced technical details that you have to deal with after you get your subdivision approved. And so everything has to be cleaned up before you bring it to the town, and then the town takes it to the county to record with the clerk and recorder. So yeah, conditions of approval are dealt with differently than the vested rights is kind of a different deal.
Thank you.
You bet.
Next,
That's all I have for you guys.
Really?
That's,
I have a question.
Jeff has a question.
Matt, thank you. Backtracking to 16.8.130 on page 97 of the packet, or 63 of your memo.
Yep.
Just, I know that in the minor subdivision applicability section that talks about 6 or less lots, right?
Yes.
In the major subdivision section, I feel like there should be somewhere, and maybe it was back in the PUD section, but where for the layperson is there some language that is the threshold for a major subdivision versus a PUD?
So, major subdivision and PUD are kind of two different. Well, they're not kind of. They are two different things. So, a PUD, you're essentially crafting zoning for your property.
Mm-hmm.
The subdivision would be taking your property and chopping it up into smaller lots. So, I don't know if that answers your question. There is on page 63 of my memo, the applicability section for major subdivisions. There's no, for a major subdivision, the language that's in there, it's kind of a catch-all. It says any subdivision that doesn't fall into any of the other subdivision categories in Article 8 is considered a major subdivision. But I mean, a major subdivision is really, I mean, it's the most complex type of subdivision, and there's really the what limits the number of lots you can do is based on your minimum lot size.
Well, I guess I'm just confused as to if I had a piece of land that was big enough to subdivide in more than 6 lots.
Yep.
Because if it was less, I would go through the minor subdivision process. If I had a big enough piece that I could divide it into more than 6 lots, where is the threat? Like, where does it become a PUD, I guess, or where does the town say, well, actually, this should be a PUD, it shouldn't be a major, like, could I come in and go, I want to divide into 30 lots if I had the land, but it's not a PUD?
Is it the school
Yeah.
district?
That's right.
The school district is not coming in through a PUD, they're just coming in through a major subdivision.
Yeah, but that's just because they're a school. Like,
No,
they don't have to
you
follow
could-
the rules. Like,
You could do that. If you
Pardon
had
me?
100 acres,
I mean, again, I know there's no 100 acres in Minturn, but if you had a chunk of land and you know, the zoning for your property said the minimum lot size is, say, 5,000 square feet, you could chop up your property through the major subdivision into as many 5,000 square foot lots as you wanted. I mean, of course, you have to be able to have the infrastructure, utilities, water, et cetera, to serve all those lots. But yeah, you don't have to do a PUD to do a large scale subdivision. The PUD would only apply if you decided, you know, I own this big chunk of land and what it's zoned through the town zoning doesn't really work for me. I want to do something creative, so I want to write my own zoning regulations. Then you would do a PUD. And in the PUD, you'd have your own minimum lot size that you came up with for your property, and then that would sort of dictate how many lots you could do in your subdivision. Does that make sense?
I don't want to get too in the weeds over it, but no.
So, but you know, a major subdivision can be a standalone thing. There's no requirement to do a PUD.
Yeah, I guess I'm just having a hard time like figuring out where it applies, because you have to have so many things in your favor, to your point about infrastructure and access to roads, and like it just, I find it hard to think about somewhere other than the school district, which is its own, they play by their own rules. But, you know, let's say Battle North and their big chunks of land south of town, and if all of a sudden they decided to come in and go through a major subdivision process versus a PUD process, I'm just trying to make sure that there's not some loophole in the code that we're now creating, or the revisions to the code that we're creating, that allows a developer to sidestep the PUD process because they can check the boxes of a major subdivision process, and because it's a giant difference of criteria and process to go through the PUD process versus the major subdivision process.
Right, I hear what you're saying, and I would say there is no loophole. The PUD process only applies if an applicant wants to craft their own zoning for their property. If what their property is zoned under the town zoning regulation works for them, they could just come in and do a minor or a major subdivision. And the size of the number of lots that they could create through the major subdivision process would be dictated by the town zoning and the minimum lot size requirements that whatever town zone district they're in has. In the major subdivision process, it's a two. I mean, it's technically a two required step process, and there's a ton of design work that goes into it. I mean, you have to, as the applicant, do a bunch of engineering, make sure that you can demonstrate you have utilities, roads, water, sewer, et cetera. And then also that your subdivision complies with the town zoning regulation. So I would definitely say there's no, it's definitely not a simple process, and it's not there's no loophole around that the major subdivision process affords anybody. I don't think.
Well, I think you probably hit the nail on the head just by saying that your lot size has to comply with existing zoning. Like, so if your new proposed, whether it's 7 lots or 500 lots, as long as they comply with existing zoning for that part of town, then you can show new infrastructure and all of those other roads and all those other things as part of your subdivision process. But you're not, since you're adhering to existing code, you don't necessarily need to go through the PUD process because you're not changing zoning.
That's correct. Yeah. So if you're zoning for the town zoning for your property said you have to have a minimum lot size of 1 acre, and you come in and say, I want to do a major subdivision with lots that are 2,000 square feet, the town's going to say, yeah, no, that doesn't work.
We don't have
So, yeah, that you have to comply with the zoning that applies to your property.
Okay, I got it.
Eric, do you have anything? Eric?
May have lost.
No, I was sorry, trying to figure this. I've been on Zoom since COVID. Let's see. No, I was just looking at, I don't know, 60%. No, I think I'm okay. It all sounds pretty good and thorough. Sorry.
That's okay. Anybody else up here have anything?
No.
Good job, Matt.
I just want to clear one thing when we go to definitions, because I think when you're referring to sketch plan is what we've called conceptual before. Is that correct? Matt?
Have a sketch plan step. It's you come in and you go straight to preliminary plat. So the sketch plan, I mean, yeah, the sketch plan is intended to be conceptual. It's really intended to be a napkin sketch of what you want to do for your subdivision. And it gives somebody an opportunity to come into the town and say, this is what I'm thinking. What do you as the planning commission and the town council think, before they spend a bunch of money doing detailed design work.
Okay, thank you.
I had one question real fast. Sorry.
No, go ahead, Eric.
Okay, so I know you didn't say you were an expert on vested rights, but does vested rights take an effect during the preliminary plat process?
Based on my understanding and what's in the code right now, once you have a preliminary plat that's approved, that is considered vested rights.
Okay.
And again, what vested rights means is when you have your approval, the town, you have a certain period of time, and it's typically 3 years, where the town can't say, we're changing the zoning of your property. Your lots that you created complied with zoning, and now they don't. So during that vesting period, if the town changes the rules, your approval still is valid. But once your vesting goes away, if you don't do your subdivision and sort of implement or perfect, whatever the right term is, establish your vesting, then the town can say, look, your vesting's gone. You need to redo some things because we changed our requirements, our
Okay.
regulations.
But it's just established during the preliminary plat process.
Correct. Yep.
Okay. That's
Thank
it.
you, Matt. What's next, Matt?
That's in terms of the from intern forward or this evening.
Yes, in terms of intern forward.
So we are we'll bring back the section on vacation of right of way at the next hopefully at the next meeting. We'll see. We need to have some conversations with the town attorney, but so we'll bring that back to you guys to have a bit of a discussion. We're also hoping to have Article 11, which deals with annexation and disconnection of land. So our hope is to have that to you soon. And our focus has shifted towards getting ready to have conversations about zoning and zone districts, which is going to be a hefty conversation with the community. So we're hoping that that'll be that will be the next step, but we're hoping to get that that process rolling here in the next month, I would say.
Thank you.
Thank you.
You bet.
Else have anything?
Nope.
Everybody's shaking their head no, so we can say thank you and good night.
Excellent, thank you, Matt.
Yep. Thank you, guys. Bye.
Good night.
Bye.
Good night.
Staff reports, managers report. Do you want to speak up, Katie?
Let's see, I'm not too sure. So I just provided that in the packet. I don't know. I tried to basically list those projects that the council has me assign. Most of the internal town manager jobs are to Jay. So anyway.
No, we
Just to
appreciate
kind
getting that. Keeps us on top of things.
Oh, yes.
Thank you.
Yeah, thank you.
Highlands Parcel Survey Public Input from Open House. That's Madison.
It is. Technically, it's Scott. But Scott's on vacation this week, so he got out of it. So, in this memo put together by Scott, I did a lot of the analysis from like the data from the survey and that kind of stuff, but Scott did write the memo, so I will try and summarize and put things the way that he did. So we had 248 participants on the online survey. And then we had about 40 people that signed in during the open house, though I estimate we were probably actually between 50 and 60 because I don't think everybody signed in, just based on, peak numbers of everybody showing up. I mean, this room, it felt pretty crowded.
Mhm.
So it should come as no shock to everybody that wildlife conservation was kind of the clear winner of the results. So when we asked just kind of general, hey, do you want this as open space or do you want this as development? About 200 people said that they want it as open space and about 50 people said that they'd like to use it as development. So that's about 80% of the people. And once we kind of got down to Minturn residents and non-Minturn residents, 114 people from Minturn would like it to be used as open space. That's about 77%, and 34 or 23% would like to use it as some kind of development. And then when we asked non-Minturn residents, about 85% or 85 people, that was a convenient number, they would like to use it as open space, and 15 people or 15% would like to use it as some kind of development. So once, if you took the survey, you'll have noticed that we had that initial question, just kind of very overarching, broad, hey, do you want this option or this option? And based on the option that they chose, they would then get 3 additional options, trying to kind of drill down on what they actually wanted. So in the development category, we gave them the option of very limited real estate, moderate real estate, or to maximize real estate. So that would essentially look at, hey, do you want to take these parcels and on the very, very low end of things, do you want to split it into maybe 3 home sites, leave the rest of, we didn't get that down to detail, but this was kind of what our thinking was. Few home sites, very, deliberate in the placement, and then the rest of it would have to be conserved because we would only subdivide it, that 3 times, and it's 55 acres. So, they'd have 1 home building, and the rest of it would have to be developed or dedicated to wildlife. And then on the opposite end of that, you would have the ability to subdivide it entirely, apartment complexes, etc. In a perfect world where we have all of the infrastructure available to serve it. So when you factored in all of the survey respondents, for the people that did choose, hey, let's try and look at development for these parcels, the main 2 responses were either very limited or moderate. I believe only 4 people chose maximize. So if you get down into Minturn versus non-Minturn residents, and I don't want to make it seem like I'm pitting them against each other, that's just kind of how I'm referring. You have Minturn respondents and non-Minturn respondents. So you have 16, or you essentially have 91% of respondents from Minturn saying that they wanted very limited or moderate, with 9% saying that they would like to maximize. That's about 3 people. And then you have 92% non-Minturn residents saying that they either want very limited or moderate, with about 8% or 1 person saying that they'd like to maximize. And then we get into what I'm sure the majority or what I know that the majority of people actually responded to, which is development of, or reserving this for open space. So of those 3 kind of options that we gave people to drill down on what they would like to see happen with the land, you have to conserve the land, but still allow for full public access, trails, and the associated amenities that go along with it, parking, bathrooms, etc. You have to conserve the land and allow for limited public access, but that don't have any amenities or parking. And then you have full conservation of land and no public access. And that is the one that won out clearly over the other 2, with about 115, I believe, respondents saying that they would like to see it fully conserved. Nobody should have access to that. So when you break it out into Minturn residents and non-Minturn residents, 52 or 47% said they'd like to fully conserve. 36 people or 32% said they'd like to conserve it with moderate or limited public access. And then 23 people or 21% said that they like to conserve it but allow for full public access. And then of the non-Minturn residents, this actually surprised me, the numbers are higher. So 56 people or 67% said that they'd like to conserve the land entirely and allow for no public access. 18 people or 21% said that they'd like to conserve the land and allow for limited. And then 10 people or 12% said that they'd like to conserve the land and allow for full public access. And so that's kind of, I know I'm throwing a bunch of numbers at you. The graphs were in the memo that was in y'all's packet. So that's just kind of the breakdown of the survey data. You get to the open house results. As in the memo, approximately 40 people, since that's what we had to sign in for, attended the open house. And of the 24 people who filled out the boards, or the 24 dots that we had filling out the boards, 75% of those wanted to keep the Highlands for open space. And the reason why I think there's a disparity, 24 versus 40, is that a lot of people, or a significant chunk of people that attended the open house, I believe, were going there for educational purposes, not necessarily to fill out the survey boards. So we definitely, there was less input received on the boards than people attended. but that's to be expected. I mean, a lot of it was just education on what the Highlands parcels were about. They'd seen our e-blasts out about it. Staff was easy access to ask questions, and there were a bunch of other knowledgeable members of the community that were attending, and so that's why we don't have all 40 people responding to boards. Just, I don't know what the percentage of 24 over 40 is. It's a chunk. It's a little over half, 60%, I think. So we did on the boards for the open house, we did purposely give people a write-in option that we did not give them for the survey. In the survey, we wanted clear-cut data points to be able to show the various boards and the public, this is what the public wants, because as seen in the supplemental document that's attached to Scott's memo of the different write-in comments, some of them were written on the real estate board saying, hey, if you want real estate, would have other options for how real estate could be developed, give us your ideas. And some of those comments were just, leave it as open space, which just that wasn't quite what the question was asking. So in the survey itself, we wanted clear-cut data points with saying, hey, this many people said this many people said this. But in the open house, we did want to give people more of an ability to write in their kind of thoughts and what they'd like to see, if they had any other great ideas that, staff and the attorneys and everybody involved in the settlement that gave us these parcels didn't think about, because I'm sure those options are out there. So you'll notice in the graphs within the memo, there's this other category, and that is fully actualized and copied verbatim from all the different sticky notes left on the boards in that attached document for y'all to read. But again, it kind of gets down to the majority of respondents wanted to use it as open space. For those who did want to see some kind of real estate, nobody said moderate or maximize. Just 5 people said very limited, with 4 people saying they wrote in comments. And then once you get to the open space, again, by far the leader is to completely conserve and allow for no public access. 22 people, it looks like, responded that, with just 5 people saying that they would like to conserve the land and allow for limited, with nobody saying they'd like full public access. So just kind of to summarize the next steps, this is the kind of beginning of a process to give staff some direction in order to go look for different funding mechanisms, whether that be Eagle Valley Land Trust, Eagle County Open Space, a private person who would like to conserve the land. I mean, obviously the person who bought the mountaintop doesn't really want to do anything with it except for build that barn to hold his equipment for maintaining that road and some of his toys for the mountain. So obviously there are people out there who are interested in conserving land. It's just kind of reaching them. And so Scott, I believe, will be looking to get more concrete numbers from those different organizations on what the town could possibly expect from the different top chosen results. Yes, I'm starting to lose words. I apologize. So that will be what Scott spends the next little bit doing and bringing back to council. So with a report on, how likely is this? There are these different things to happen. What can the town expect? The timing of what the town can expect. Just with more general information on this process. Now that we have, clear cut, this is what the public wants to happen here.
And it's my understanding that this is a major migration area.
It could very well be.
I mean, that was brought out numerous times, once when I watched it on council and once, a couple times in this room. And then Scott is on the Eagle Valley Land Trust Board.
Yes.
He always states that, so we all know that. So he is getting some good information because he does work with that.
But to be clear, the direction on this is being driven by the council, correct?
That's correct. It's
We don't really have much stake in driving the bus here.
the memo is certainly in your packet to keep you informed,
Yeah.
as a staff report. But you're correct, since it is public land owned by the town council will be the one who decides what happens with it. But obviously, your voices are still needed, and we certainly want to hear from everybody in town.
Do we know who provided that little blurb about Pitkin County and their $27 million to conserve their land? Was that through, who provided that info? Scott, maybe?
No, so this is write-ins that we received on the board. Scott would not have written on the board.
So somebody just put that
Somebody wrote it in, yes. Obviously, no names were associated.
Now there's the convergence of 3 different trusts.
Yeah, it was over in Aspen.
Yeah.
Aspen Valley Land Trust, Eagle Valley Land Trust, and Pitkin County
Yeah.
together.
I mean, that's 4,000 acres. That's
Right,
pretty big.
that was a big acreage.
I wonder if that's like where the tree farm and all that stuff is. Because they've got a lot of Aspen employee housing down in there now. Real tiny homes.
Great explanation, Madison.
Yep,
Thank you.
good job.
I'm better with numbers than I am actually presenting them. I liked doing all the graphs, but I was very glad that Scott did the actual memo.
There's a lot of info and you put it all out there.
Thank you. Just as a heads up from like the minutes standpoint, I know I typically go through and copy all of the staff reports into the minutes. But between this staff report and the 2 town manager staff reports, that would add 15 extra pages to the minutes. So I will not be doing that this time. I will likely just summarize.
Okay.
So you know not to expect a complete copy.
All right.
That's all right. I already got Katie's report.
Well, does the commission have any comments?
No,
No.
All right. Learn
Future
a lot about
meetings are
PUDs.
March 12th. Everybody here. Eric,
Yes.
are you gone anytime in the future month of March?
Nope, I'll be here in March. Be there in March.
Anybody else?
the week there, 17th, I'm gone, but not 12th.
Are you back by the 26th?
Yes.
Okay. Jeff,
I'm here.
I'm here.
March, yeah. I'm here.
We will ask Amanda later.
As a reminder, planning commission applications, if you have not gotten them to me, are due
March 13th.
March 13th.
And that's Amanda and who?
And
Me
Lynn and Daryl.
All right.
I'm working on it, but I have to handwrite it, so it's like I gotta figure out just how to specifically say it and make it tiny and make it readable.
I'm sure you're really gonna get grilled.
Well, that depends on how many people show up. If it's 3 people, no, I will not be drilled. I think in the last, how many, well, even with you, there's only one time I can remember we had 2 or 3 openings and we only had 1 person more than what was here.
The only person that grilled me was Hawkeye the first time.
Okay.
I didn't make it.
Yeah.
You didn't make it.
It took somebody else.
Well, I don't think Hawkeye was mayor when I was here, because I started back in 07 or 08. Because it was the very beginning of Battle Mountain. And I don't remember who the mayor was.
Don't worry, in the 90s, I applied like 8 times.
It would have been Hawkeye?
Nope.
This Daryl, that was
Persistent.
just kidding.
But maybe they didn't
I
have
remember
enough
it
people
was quite,
applying.
you were quite on.
That's where,
Okay.
Okay, we're getting off topic.
Okay.
now we're having a casual.
Oh,
Casual
the
conversation.
conversation can happen after we get off
Okay,
the
she
recording.
wants the adjournment.
Yes, like the adjournment first, please.
Yes.
Is that it? Can we make a motion?
Yeah,
I make a motion to adjourn tonight's meeting.
I'd like to second that.
all in favor?
Aye.
Aye.
You can talk amongst yourselves.
We did
Yeah.
good.
Yeah.
Okay.
Is it-
Thank you.
we'll just-
Thank
we'll
you,
just-
Eric. Have a good one.
Thanks, Madison.